Hey everyone, I'm Kevin Gosztola, managing editor for Shadowproof. Thanks for your patience. I was just getting things together for day one report on Julian Assange's, it's not Julian Assange's appeal hearing. I got to make sure I do that correctly. It's the U.S. government's appeal hearing. They are appealing the extradition decision by the district judge in the United Kingdom who ruled against the extradition of Julian Assange to the United States back on January 4th. And we've discussed some of the grounds for the appeal. All five of the grounds we've laid them out for you, but just to refresh your memory, these grounds for appeal are what was central to this appeal hearing today. And we heard from James Lewis, the lead prosecutor from the Crown Prosecution Service, who was making the argument on behalf of prosecutors. And you went through all five of these, suggesting that the judge did not follow the extradition law that is in the UK, which was passed in 2003, that the judge did not allow the government to provide assurances when it became clear that she was going to be concerned about the potential prison conditions in the United States. And then the fact that she gave weight to Professor Kopelman and did not discredit or give little to no weight to his psychiatric evidence after he misled the court on Stella Morris being in a relationship with Julian Assange, and the fact that Julian Assange had two children. We'll get to more of that. But then also this idea that they never really planned to put Julian Assange in ADX Florence, a supermax prison, or under SAMS. And so she should have sought assurances in order to clear that up. And then there's the idea that she didn't do the assessment of the risk of suicide correctly. And finally, that in fact, these are our assurances that we are putting forward now that the decision was against the United States. So now they're coming forward with these assurances. And for the first time, Julian Assange's legal team is able to contest them. So thank you for joining. For those of you who followed the reporting from day one that I was doing on Twitter, thanks for following along. And I'm going to go through some of the highlights, and then there's going to be a report that will be available. I highly encourage you to go to thedissenter.org and become a subscriber there if you are not already. This is where all the updates and reporting on Julian Assange's case are sent. And I'm actually collaborating with Mohammed Almazi, who is in London, was able to attend the court today. And we're going to work together on a report on the proceedings. So I really encourage you to make sure you're subscribed so that will get to your inbox. You'll be able to read it along with some of the other reporting. Let me say that I was a bit astounded because there were dozens of people that were tuned in through the video feed today, quite a lot. There were court reporters that typically do a pretty good job on legal cases in primarily New York City in the United States, but they cover other cases in DC, Washington, DC. But there were people from Courthouse News, Law 360. I saw a Guardian reporter who's familiar, but notably I saw that Michael Isikoff tuned in for some time. He's the Yahoo News reporter who broke the bombshell story along with a couple other reporters, Sean Naylor and Zach Dorfman, about the CIA's plans to kidnap or kill Julian Assange. And so now having that break and gain widespread attention, I think he now feels some responsibility to follow. And I actually believe that report likely played a role in pushing many more organizations to take an interest. It seemed like there were, maybe not as much as we would like, but there were at least a half dozen or more people from some of the more establishment media outlets in the US who were tuned in. I hope that coverage translates. I hope the fact that they were there translates into some coverage that gets this out there. But there's a lot of complexities with this hearing. And if you have not been following this for a lot of the past, year, it's difficult to jump in now and understand where we are at in the case. And so if you didn't report on the extradition hearing, which Isikoff and other people who had tuned in today did not, I think that it's possible you might lose out on some of the nuances that are important in understanding what's significant here. So it's not to say that they're going to be putting out false reporting, but just to say that I think you really want to look for people who have been there since the extradition hearing. And I think those who are tuning into this know who those people are. Those people are out there. They're Richard Medhurst, Mohammed Almazi, and Consortium News with Joe Laurie and Kathy Vogan being involved. And then Juan Passarelli has followed it. He's a filmmaker. Taylor Hudak has been doing work through Activism Munich, Tariq Haddad, people like that who have been putting out reports, who have been doing this diligent work and not just parachuting in when it becomes something that could potentially be lucrative to cover if you're a mainstream news outlet. I think that you really should stick to the independent news media who has led the way, and understandably led the way because of the fact that they do not have this conflict within them over whether they can cover this case in a manner that communicates the threat to press freedom. Because a lot of people in the establishment press, I believe, are self-conscious that if they really acknowledge the threats or the risks to Julian Assange, and people are going to say, oh, so you like Julian Assange? Oh, you think Julian Assange is not a Russian plant? Oh, you think Julian Assange isn't somebody who is an egomaniac? Because that's the way that these people think in these elite circles. And so then they get defensive. And I believe that there's a lot of journalists who have wanted to give this attention, but run from it because they're afraid of what it's going to do to them. And they're not willing to stand up and do reporting that exists on its own without, having to add important caveats, which are unnecessary to communicating what's going on. So with that kind of preamble and setup for all of this, let's get to today's event, because in the beginning, what we saw happen with the court was that James Lewis spent most of the first half hour belaboring this point about ADX Florence, Colorado, the Supermax prison, talking about the special administrative measures and emphasizing that this was something which the judge believed was a realistic possibility that Julian Assange could be held in these conditions, even though they disagreed, even though the United States, as a requesting party who wanted to extradite Assange, even though they said he's not going to be held in these conditions, that was the position of the defense. They did not accept that the government would not put him in these conditions. And then the judge decided that there was enough evidence to believe that he could be put in the Supermax prison, or that he could be put under these special administrative measures. Now, special administrative measures are designated by the Attorney General. In this moment, that would be Attorney General Merrick Garland. And I have to digress because Attorney General Merrick Garland is totally missing in action at a moment when he should be taking responsibility for what has unfolded, the way in which the shameful recklessness and the brazen hostility of the Trump Justice Department has reared its ugly head when it comes to this case. The fact that the Justice Department departed from its approach, which they had under Obama, to not proceed in charging Julian Assange because what it would mean for editors of publications like the New York Times and Washington Post that published documents from WikiLeaks if they were to go forward with a case under the Espionage Act. And so it's really important that we consider all of this and recognize that. So we recognize that Merrick Garland has the ability to drop these charges. Sorry, I had a little bit of a hiccup in my thought process there, but we recognize that he could do something, just like he could do something for Stephen Donziger, who has now been put in prison in a case where Chevron has hijacked the judiciary process in order to pursue a vindictive, retaliatory attack on Stephen Donziger for being successful. The same way that is marred with corruption and abuses of power and issues of due process and human rights violations that have been singled out by the United Nations. In the same way, United Nations representatives have also said similar things about Assange's case. And in both respects, Merrick Garland is totally MIA, not there to do anything about it, pretending like it is not his responsibility, which is the position of the Biden administration in its entirety, to say that if reporters ask them questions about this case and object to the handling of this case, that they are not going to directly respond to criticism. So the start of these proceedings was going over and over again on this point of ADX Florence and SAMS, and making it clear to the court justices that this was not something they intended to do. And so then they also say that because we are now offering this quote unquote assurance that he will not be put in SAMS or a Supermax facility, that then none of this matters anymore. And they believe that since a large part of the reason to not extradite Julian Assange, because it would be oppressive for mental health reasons, stems from the belief that he would be put in a Supermax facility or held under SAMS. So if you don't have that, then they believe that deals with a lot of the argument or a lot of the conclusion that he would face oppression. And tomorrow, the defense, the legal team for Assange, will be able to respond to that thoroughly and deal with it. And of course, the issue is that there are other ways in which they can manage Julian Assange and restrict his communications, put him in conditions that do not allow for contact visits with his partner, Gisela Morris, and with his children, and to make it impossible for him to have phone calls with some of the people who are probably in his support network right now, who he can call from the Belmarsh High Security Prison. And that's if he's put in a communication management unit like Daniel Hale, who is in a CMU in the United States Penitentiary in Marion, Illinois, or in the institution in Terre Haute, Indiana, that also has a CMU, then he will face these conditions that could exacerbate the depression that he has. He could exacerbate the mental problems that he is enduring. And so this was how the proceedings started. Also, he says that, it was never the position of the prosecutors that they did not have to offer assurances, but just that they weren't going to, because they didn't believe that Julian Assange would realistically be put in SAMS or ADX Florence. So there's these gymnastics that the prosecutors are doing in order to come in at this late stage and make these pronouncements to the High Court of Justice in order to salvage this case. And as the proceedings unfolded, we got into some conversation. James Lewis put forward some arguments around sentencing and the fact that during the proceedings, they looked at the different charges and how it could stack. And because Espionage Act offenses can carry a maximum of up to 10 years. And then he also faces the computer crime offense. So there's 18 charges that Julian Assange faces, that in total he could face up to 175 years in prison. And the prosecutors look at that and they go to prior Espionage Act cases and say, well, Reality Winner was sentenced to prison 63 months. That's the longest sentence for somebody found guilty of an unauthorized disclosure under the Espionage Act. And so that is probably the highest. Most recently, Daniel Hale received 45 months in prison. And so that could be what Julian Assange receives if he is put on trial. But that was pleading guilty to one charge. And pleading guilty to that one charge got him the 45 months. And there are other charges. So we know Julian Assange would likely be convicted of multiple offenses, or could be convicted of multiple offenses. And then there's the issue of the fact that Daniel Hale was someone who was able to give a statement for 15 minutes in front of this judge named Liam O'Grady and present himself in a manner that communicated to the judge that he was a conscientious military veteran who had been in the Air Force, who was involved in the drone program, who had moral injury, who had an issue with what he was being tasked with doing and carrying out. And so that was something that resonated with the judge, and the judge had a lot of respect for what Daniel Hale was saying in his courtroom. And I think that was shown and reflected in the sentence. And if you think that that's going to happen with Assange, that is totally ridiculous. We all know that any judge that is presiding over this case will have this feeling that Julian Assange is a repulsive figure, that they will, there's so many reasons, because of the way the media has covered WikiLeaks, because of the attitudes of the security agencies, because of how politicians have discussed and developed their understanding of WikiLeaks, that they would have extreme prejudice against Julian Assange. And I doubt that no matter what Julian Assange says in a courtroom, if he had a chance to make a statement similar to Daniel Hale, I doubt that any judge would look at that and find anything in there that said, oh, you are a conscientious person, you are a stand-up person, you are someone who deserves mercy, and I will find a middle ground between what your defense attorneys are saying, that you should not be put in prison at all because you've served time in Belmarsh, and because of the time that you've been under arbitrary detention as understood by the United Nations. But then, okay, let's say they're recommending 15 to 20 years for Julian Assange to be put in prison. I don't see how a judge says, okay, I'm going to average that out and give you 6 to 7 years or 7 to 8 years or whatever. They are going to probably go closer to what the prosecution wants, given their disgust for Julian Assange as an individual. That's just the way that I see it. So I don't think Daniel Hale is comparable. The only way that Daniel Hale has any bearing on what's unfolding is when you consider that he's been put in a communications management unit, and an assurance was put forward by the prosecutors and the judge and the attorneys. You know, they all got together, and I think the prosecutors could be said to have assured them that because Daniel Hale has post-traumatic stress, that he would go to a federal facility in North Carolina called Butner Low. It's a low security prison. It's a medical center, and that they would send Daniel Hale there, and he could be in that facility so that he could receive regular attention for post-traumatic stress. Prisons aren't a good place for medical care. They should never be considered places where you should receive medical care, but it is probably true that medical facilities are better equipped to provide that kind of attention, more so than the facility in which Daniel now finds himself, which is Marion, the USP Marion in Illinois. And so this assurance, having gone back on that, is one in which we could see take place with Julian Assange. And yes, the amazing thing is that James Lewis will look right at the High Court of Justice, look right in the justices' faces and say that there's really no way that these assurances could ever be undone, that they are binding, that they are binding. Like, binding on whom? Who? What? Under what consequence? I mean, it's not like if they go against the assurances that they are putting forward for Julian Assange, that there's going to be some kind of consequence to them. There really is no risk to the US government if they do what they please with Julian Assange when he is brought to the United States. There's still going to be extraditions between the United Kingdom and the United States, no matter what they do with their handling of Julian Assange, unless they just decide that the only people they're going to start targeting going forward are journalists. But I happen to believe that there's going to be a range of people, and then maybe some journalists or dissident activists, or maybe people who are helping Iran or Venezuela get around sanctions because those are crippling and are driving people to go hungry and something like that. But, I tend to believe that there really aren't many consequences that the U.S. government is faced with if they would abandon these assurances that are put forward before this court. And then there's a few examples that are raised of the U.S. government actually abandoning these assurances, like one in the case of an individual named Harun al-Swat, that was a terrorist or a terrorism-related case linked to Abu Hamza, this extremist preacher who was implicated in violence. And when he was brought, they didn't exactly follow the assurances that were put before the court. Well, James Lewis just brushes that aside and acts like that's not really a big deal. And then we move along as if, to say that, okay, all is okay. So we also had that the Laurie Love case came up. This is a really important precedent. The High Court of Justice denied the extradition of Laurie Love. Laurie Love is somebody who I believe is a computer scientist and an activist who's accused of hacking offenses by the United States, but had these conditions of Asperger's, a diagnosis, much like Julian Assange is diagnosed with Asperger's. And then there's eczema and also asthma that Laurie Love had as a diagnosis. And so what James Lewis and the U.S. government is trying to do in order to differentiate and make it seem like Laurie Love's case and Julian Assange's case are not the same is to say, actually, Laurie had mental health problems and physical health problems. And we believe that the physical health problems were really the decisive factor in the decision by the High Court of Justice to deny the extradition. And because Julian Assange doesn't have these physical ailments, we can't really rely on this as the controlling case that would determine how to handle Julian Assange's extradition. And that's also wild because he does have physical problems. And I think there's this thing that we shouldn't do, which is ignorant, to separate the mental from the physical and act like they're not connected, to pretend or put on this sort of smokescreen to suggest that mental health issues don't cause physical problems for individuals. And then put that aside from the fact that he actually does have a problem with osteoporosis and his bones are frail. So if he cracked ribs or had problems while he was in prison, there's no way he would get the appropriate medical treatment. In fact, he could also find that it could get so severe that he lost mobility while he was confined in a federal facility. And does that amount to inhuman treatment or torture or being in a predicament where the U.S. isn't going to take care of his health? Because this has happened to prisoners. This happens to people in the United States. This is the problem for the Crown Prosecution Service representing the U.S. government. We have numerous organizations in the United States that can document abuses and treatment that rises to the level of torture. The United Nations has had people who have come to the U.S. to investigate solitary confinement and other aspects of the U.S. prison system to show that this is horrible, horrible conditions for people to be held in when they are under confinement. And so now this is the issue. This is what the these prosecutors have to deal with as they argue this case before the high court. There's this whole thing about resisting suicidal impulses and the fact that Julian Assange has to be shown to lack the capacity to resist those impulses in order for his life to be saved from being extradited. And if they cannot show that, if they can only say, well, he might voluntarily choose to take his life, then that's not good enough to deny the extradition. And it was Professor Michael Kopelman, the psychiatrist, who was closely assessing and treating Julian Assange between May 2019 and the end of December 2019, who put forward the evidence that was relied upon by Judge Vanessa Baretzer and convinced her that, in fact, he would not have the capacity to resist taking his own life in a U.S. jail or prison. And they, the prosecution, have responded to this part of her decision by moving to disqualify Michael Kopelman on the basis that he misled the court when he knew that Stella Morris was in a relationship with Julian Assange and she was part of the legal team, and that Julian Assange had fathered 2 children while he was in the Ecuador embassy. And so having that information, believing that that was not brought forward in a manner that was supposed to be done because he's an impartial expert. At least that's the kind of pledge he makes to the district court, that he will be impartial. They would like the evidence that he has given, which played a crucial part in denying the extradition, to be given little to no weight. They play this game where they're like, well, we didn't move to exclude it, but we think that it should be given little to no weight. I don't really see any difference, but whatever. So Michael Kopelman, they are going after, and the defense's response to all of this is to point out that, and you'll hear more about this on day 2, we can get into this, but to say that there were real issues of privacy, of wanting to protect the family from being under potential threat, because UC Global was involved in an espionage operation. This is a Spanish private security company. UC Global was involved in an espionage operation against Assange while he was in the Ecuador embassy. It was targeting Stella. It was targeting babies that were brought in. They were trying to do paternity tests to determine if those children were actually possibly Assange's. So they have these operatives that are digging around the embassy, looking for anything they can find to help them incriminate Assange, help further their pressure campaign in order to force him out of the Ecuador embassy. And they are passing on audio and video feeds to the CIA, so they're able to follow along what is happening in the embassy. We know that journalists are visiting. They're having their electronic devices tampered with. All the visitors or guests who come there are subject to what really amounts to a kind of harassment campaign through the security checkpoint, kind of intimidating. You have to leave your personal belongings with them when you go in to meet with Julian Assange. And while you leave those possessions, they can rifle through them. We heard evidence related to that during the extradition hearing in September 2020. So all of this contributes to that decision to be very careful about when it is revealed to the court and how it's revealed to the prosecution about what this relationship is. And it's not until they're seeking bail in March that finally it's brought out there. And also the judge was not willing to allow it to remain not disclosed. And so because it was something that was going to be public, and then also media became aware of it, then it was something they had to own. Even more important than all of that is the judge making it very clear in her decision that she was not misled, that she didn't even get the evidence that is at issue here until after all of this transpired. So, by then, it's not like it has any bearing on whether she thinks it's significant that Julian Assange cannot resist the capacity or lacks the capacity to resist suicide. And so these are all things that we went through. We spent a lot of the afternoon going through this. And James Lewis read from transcripts, rather difficult to follow. He read through these transcripts, going back and forth from all these doctors. Again, the issue for them is that one doctor was not given enough credibility or was not seen as being as credible as Kopelman, or that Kopelman, his testimony was favored by the judge, and then they feel they're at a disadvantage because their doctors, what they said, were not treated with the same significance, were not treated as being as good at what they were doing as Kopelman. And they seem to take great offense at this, even though that's exactly what a judge is allowed to do. When the witnesses come before her court, she hears it, she listens, she tests the integrity of those individuals, and then she makes the determination about, based on what she heard, what she's going to, how she's going to calculate her decision, how she's going to formulate the way she is about to rule. We know that this happened with Julian Assange when it comes to whether they view him as a journalist or something else. And clearly she did not want to say that what his actions did were protected by journalism. And then this is like a political case that the US government is pursuing against. And so the people that the defense put on the stand to make testimony about this, it's very clear that they were not persuasive. These were not people who convinced her differently about Julian Assange. But you don't hear the defense going in there and attacking the character of Vanessa Baretzer and being like, well, we're upset that she listened to this witness. We were upset that she favored Gordon Kronberg, the prosecutor, and didn't like our witnesses that came forward to testify about Assange being a journalist. And I know that issue isn't before the High Court of Justice, but it just, it goes to, it's my way of saying that that's not really how you're supposed to pursue an appeal. These are supposed to be on matters of law, not like I'm upset that the judge played favorites when it comes to like certain witnesses. You have to identify that these witnesses should have been given attention based upon the law. I don't know legally that there is any obligation that they equally weigh prosecutors' doctors with the defendant's doctor. There's nothing that says that a defendant's doctor can't be treated as more credible as the prosecution's doctors. So hopefully that makes some sense. And as we get to the end here, one thing that was really absurd, probably one of the more, there's a lot of things that don't make a whole lot of sense in these proceedings, but something that was a total fantasy on the part of James Lewis to float. I'll conclude with this. And then if you have any questions or any comments, I'm going to go through them, be happy to respond to them. And once again, thank you for tuning in and following this work that is being done, the journalism that I'm producing. One of the things that James Lewis said was that the judge did not consider what could happen if he was acquitted, or the possibility that he would not be an ADX Florence because because he would be able to go before a court. He would be able to apply for a speedy trial, and then he would be able to challenge the Espionage Act prosecution on First Amendment grounds, and then challenging the prosecution on First Amendment grounds that he would win, and then he would somehow be set free. I don't know what cases they're thinking of. I have no idea why anyone should think that James Lewis knows what he's talking about after floating such a improbable scenario. That's a fantasy. It's not even I like rosy scenarios. I want Julian Assange to no longer be going through this because I have a stake in this. I do not want to be prosecuted for doing journalism by the United States government. But I do not think there is any chance that Julian Assange can come here and put on a First Amendment challenge to the Espionage Act, because it's been tried before. There are people who have been prosecuted who are whistleblowers, people who those accused of unauthorized disclosures of classified information, who worked in government, who were contractors or National Security Agency employees, have tried to challenge it on First Amendment or even just plain old constitutional grounds, that it's too vague, that it's overbroad. Fail, never succeeds. The idea that Julian Assange and his attorneys are going to magically find something that prior legal teams for these people were not able to identify doesn't make any sense. And the fact that I suppose they're saying, well, it's expanded into a publisher and it's no longer a source, so maybe they'll be able to say they're violating his First Amendment rights. But that also depends on whether a court is willing to classify him as a journalist. And thus far, in this extradition case, he's denied that right to be seen as a journalist. These courts, government agencies are labeling him as something that he isn't. And if that's what he is viewed as before a U.S. court, there is absolutely no way the First Amendment would ever be applied to him. This is drawn up in a way that threatens publication, that targets journalism, but the words that are used by prosecutors are deliberately sequenced so that Julian Assange is singled out as something more nefarious and different than a journalist. And we all know that because we've seen the attacks in the press against him to make it seem like he's much more different than your average independent journalist who engages in advocacy. So there's that. And then apply for speedy trial. I have no idea what James Lewis could possibly be referring to. I mean, it doesn't really work that way. And then with the volumes of classified information that are involved in this case, it's going to take some time for this trial to be put on by a court. There's all sorts of security precautions that you have to go through. He has to have time once he's in the United States with his legal team to put together a case. It would be a year and a half probably, I'd imagine, before he would have his case. I'm saying that based on my knowledge and experience covering Chelsea Manning's court-martial and what the classified information in that case did to delay the trial for Chelsea Manning. That effect would also be present with Julian Assange's case. So again, like hearing James Lewis talk, I'm not sure that he's being realistic. I'm not sure that he's based in the real world. I don't think he's grounded. I don't think the Crown Prosecution Service is grounded in the reality of the judicial system that exists in the United States. Obviously, because to acknowledge the way it fundamentally works, the way it is intrinsically set up to be able to go after political prisoners like Julian Assange would be to recognize, it would bump up against that fact that they really should not be pursuing these charges against Julian Assange. So that's day one. There was a rebuttal from Edward Fitzgerald, who represents Assange, for about a half hour. There's not a whole lot to say that I haven't already articulated here, but I think he took the tactic of focusing on the judge and saying he believed the prosecutors were being unfair to the judge and that she was well within her right to rule the way that she did, and that her argument was, in fact, carefully reasoned and laid out. And he's talking about the particular section that's relevant to the hearing. We are setting aside the other portions in which she came to conclusions about Julian Assange that were unfair or perhaps inappropriate, or didn't recognize the hostility that was within the U.S. government and in the CIA, etc. And we're just focused on the small portion, the oppressive for mental health reasons part that led to Julian Assange not being extradited. so far. So thank you for tuning in. I'm going to go through some of the comments and the questions that we have here. There's quite a few of you tuned in. I'm glad to be able to share this reporting with you. I hope that this is beneficial. I hope you have a better understanding of this case, can talk about why it's significant beyond maybe some of the more the slogans, to go beyond just saying free Assange, but to be able to recognize the machinery, the gears that are grinding and how they are being turned in order to get Assange to the United States. So let's see what we've got here. All right. Good to see you, Deb. Thanks for tuning into the reporting. Tom, good to see you. Got some good friends who tuned into the reporting. Right. I did not mention Stefania Marizzi, but Stefania was tuned in. Stefania has done incredible work on FOIAing, submitting Freedom of Information Act requests in order to try and get records from the countries which we know have targeted Julian Assange. I have someone thanking me for calling Garland out. I'm incensed that Biden is visiting the Pope today, too. I can't really say that I have any strong feelings either way on if Biden meets with the Pope, but I do note that Merrick Garland was before the Senate today to testify, and I would bet that Julian Assange did not come up at all during those proceedings. If my bet is incorrect, let me know. If you have seen something that has been shared that a senator asked about this case, but I'm going to guess that no senator really cares much about how the Justice Department is handling perhaps the highest profile case that the Justice Department has right now, because they didn't take up Stephen Donziger's case, and that's why he is in prison. Mickey stops by and says, keep up the good work. Thank you. And then we have Darcel, loved your updates. Thank you. Thank you for tuning in. And then Shona says, no trust in a regime that would plot to kill him in London, spy on his attorneys, spend millions on surveying him, and commit crimes against him in the embassy. No assurances that can be believed. I would agree with that sentiment. And all right, so we're winding down. I'm going to go work on the report that will be sent out and shared. And once again, let me put up the URL for that. Some of you have come in the latter half of this broadcast. This will archive, and on the Shadowproof channel, you can become a subscriber and then get alerts when we go live just by hitting that subscribe button. And then you should be able to know when we do go live, and I'll do the update. I'll do the end of day report. I'll wrap this all up tomorrow on day 2. There's also going to be a panel. There's going to be a panel with Stefania Marizzi and Chip Gibbons and myself, and potentially maybe Rebecca Vincent, and she's with Reporters Without Borders. And this will happen at 3 p.m. Eastern. And so that would be at 8 o'clock p.m. London time. Really, maybe not the best time for people in Australia. I know that I usually get people in Australia tuning in, but there's not really much we can do about that. That'll be the end of a long day, and we want to do something in the middle of the day before everybody moves on from the Assange proceedings. It's not really clear when we will get a decision on the appeal. I don't know that it'll be this week. I think it'll be several days before we really know what's going on, with, how the High Court of Justice has come down on this appeal from the United States government. So the way you stay up to date and know when there is that ruling, that decision you subscribe to the dissenter.org if you have not already, and we'll send a report. Any coverage that is done on Assange, I'll send out to you at the dissenter.org. And then you can also follow me at Gosztola and get up to the minute updates from the proceedings that are happening before the High Court of Justice. So to all of you, I thank you very, very much. I'm so pleased to have dozens of you who care and take an interest in my reporting, and thank those who give it a boost on Twitter. Once again, Glenn Greenwald took a notice in the reporting, which gives that a boost. It lets more people find my reporting. And there are others that have sizable followings who have turned people on to the fact that I have been here doing this coverage. And that's good. I don't want to get drowned out by the establishment media who have suddenly discovered the Assange extradition case at the appeal stage. So it's good to be able to still break through. And with that said, I'm going to go write my report. I'll be collaborating with Mohammed Almazi. And then it's going to be up at thedissenter.org at some point today. And I will share it on Twitter, and I'll post it to the Shadowproof Facebook page. So until tomorrow, until day 2, see you around.